Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to talk about divorce in Connecticut when one of the parties to the divorce is employed by Gartner, which is one of the larger employers here in Connecticut. So most aspects of the divorce are going to be exactly the same as any other divorce, regardless of where that person works. So child custody, you're still going to need to figure out the custody schedule of the kids depending on, the parenting history and everybody's availability. Child support will depend on income and what the custody schedule is, whether or not there's any alimony. That is the same as any other divorce, as well as division of debts that you may have and division of most assets. So all of those aspects are not different, and I've created other videos that cover those specific topics and how they are dealt with through the divorce process. Now, if either you or your spouse are employed by Gartner, there are certain retirement accounts or other investment accounts that the Gartner employee may have, which are different than most other individuals. So there will be a 401k plan, which is pretty traditional, which is essentially a retirement plan where both the employee and the employer make contributions to the plan. And it's an asset that you have that can be divided in a divorce. You might divide it 50-50, or you may say the portion of the account that was accumulated during the marriage is divided 50-50. And that is done through what's called a QDRO, QDRO. It's short for Qualified Domestic Relations Order. And that is a legal document that is essentially filed with the court, which can divide that 401k plan and separate out a certain portion of the plan, giving it to the other spouse without there being any negative tax implications. So there's no early withdrawal penalty if you divide the 401k plan in a divorce. So there's the 401k plan that the Gartner employee will likely have, and then there is the ESPP, so the Employee Stock Purchase Program plan. And that is pretty niche and not very common. Most employers do not have this type of plan. And it's essentially a program that allows employees to buy Gartner stock at a discounted rate. Usually the discount is between 10 and 15%. So if the stock is trading at $100 a share, for example, which it's significantly higher right now, the employee in that scenario would be able to buy the stock for somewhere between 10 and 15% reduction, so $85 to $90 per share. So they would own that stock, and that is funded through payroll deductions. So, X amount of dollars comes out of the pay period, out of every paycheck, and the employee can, elect whether or not they want to be in that program. But most people will elect to be in the program because of the discount rate that is offered. It's essentially free money to a certain extent. And so the deductions come out, they're held in an account, and then every certain period of time, usually every 6 months or 12 months, the funds that are held, that have been taken out of the paychecks are used to purchase stock in Gartner. So the employee of Gartner will own Gartner stock. And there's a maximum amount that an employee can purchase. So it's $25,000 per year. That's the IRX cap on stock. And, so how long they keep that account can impact the tax implications. So as long as they keep that stock for anywhere between 1 and 2 years, then any increase in the value is taxed as capital gains rather than regular income. So let's say the stock is worth $100 a share, and then it jumps to $200 per share when the stock is sold. If that is sold in a short period of time, if it goes from 100 to 200 and is sold 6 months after purchase, then there would be $100 of income tax that is paid on that gain. Whereas if it is held for a longer period of time, usually between 1 and 2 years, you want to talk to a financial advisor about the specifics of how long it has to be held. As long as it's held for that longer period of time, it is the income on that. So the increase in the value of the stock is taxed as capital gains, which is a significantly reduced tax threshold. So the reason this is relevant is you need to be aware of the fact that there may be some tax implications on the funds that are held in that stock. So if one party has, $100,000 worth of Gartner stock, you don't necessarily want to trade $100 in cash for that stock. You wouldn't want to trade $100,000 in equity in a house for $100,000 of Gartner stock, because there are some taxes that need to be paid on that $100,000 in stock. Whereas if you have $100,000 in cash, there's no taxes that are owed on that, presumably. So you want to make sure you're speaking with your attorney or financial advisor about what the stock is actually worth after taxes. And you certainly don't want to just say one party, the party who is the Gartner employee shall sell all of their stock and pay, 50% of the value to the other spouse, because you need to clarify who is responsible for the taxes on that stock. So that is, those Gartner shares are going to have to be dealt with in a divorce and divided up. You just want to make sure you're speaking with your attorney and financial advisor, if you have one, about the implications of what that asset is actually worth. So as a Gartner employee, if it is you or your spouse, it's really that ESPP plan that differentiates the Gartner divorce from your traditional divorce. And then just one other thing to be aware of is that Gartner employees generally have very good health benefits. So if you are married to a Gartner employee and you're getting a divorce, if you're, after the divorce, you will no longer have those benefits. You will have to go on your own, employer's plan or get a private plan on the healthcare exchange. But you just want to be aware of the fact that, okay, if you have medical procedures or, routine stuff, your medical expenses may be significantly higher than the medical expenses of the Gartner employee. So you just want to take into consideration essentially the value of that health insurance plan when you're negotiating things like the division of assets, or particularly alimony or child support. You will want to factor in that if you are no longer on that health insurance plan, your expenses could be higher than the person who is still a Gartner employee. So those are the basics of divorce when one of the parties is a Gartner employee. As usual, if you have any questions, you can feel free to contact our office. And if you are going through a divorce or other family law case and either you or your spouse is a Gartner employee, we would invite you to contact our office if you are looking for legal representation.